looking for?
Yep.
All right, so welcome everyone. Thank you for coming. I'm Melissa Levine-Piro. I'm an attorney here. I practice in family law and business law. So tonight I'm going to be presenting in the seminar what every woman going through divorce needs to know, along with attorney Katie Murphy, who's also a family and divorce attorney here, and Renee Senes, who is a certified divorce analyst and financial planner. She's going to be presenting after us for about 45 minutes on the financial aspects. So the purpose of tonight is really to walk you through the procedural aspects of a divorce, the financial aspects, answer your questions, kind of answer questions to misnomers and, rumors out there and what your friend who already went through a divorce told you that isn't true necessarily, and answer all those questions and give you a really clear idea of the process. So our bios are on this page if anyone's interested. They're also on our website. And I'm also just going to introduce before we start Carolyn Romano. She's a special education attorney here, and attorney Amanda Castro, who's also a family attorney who's filming us tonight. So this is something we created just for tonight to give you an idea of what the divorce litigation process would look like. So it starts with somebody filing a complaint for divorce. It's then served on the opposing party, so your spouse. After that, there's going to be a case management conference and or motions for temporary orders. Then there's going to be a four-way, which is a settlement conference between the parties and their spouses if they have any. Attorneys, sorry. Then there's a pretrial conference, and then either you're going to get to a separation agreement, which means you agree on all the issues and present it to the court and things are done, or you're going to go to trial. And the court gives you about a 14-month track for the divorce life cycle to take place. In reality, the divorce life cycle can be anywhere from 2 to 3 years, depending on how much people are in and out of court. So we're just wrapping up now some 2013 divorces, unfortunately, because the parties were very litigious. It doesn't have to be this way. We've had divorces that have lasted 2 weeks. We started a divorce 2 weeks ago, and we're probably going to have it settled at the end of the month.
Yeah.
So it really just depends on the parties, and we're going to go through each of these phases with you in the next couple slides and kind of talk about the details. But a couple notes that we wanted to let you know about is that Massachusetts is a no-fault state. So we do have fault grounds for divorce, like cruel and abusive treatment, adultery. They're archaic. Nobody uses them. In all the divorce cases, my background's in domestic violence. I've had like 3 enter for cruel and abusive treatment, and you're talking cases where someone's incarcerated and our client has like almost died because of the abuse, and there's police reports to support it. All divorces, no matter what the other party did, are entered under grounds of an irretrievable breakdown of the marriage. It's a no-fault statute, and that's just the way it is. And I know that's really hard for people to hear, depending on the conduct of the parties, but that's just how Massachusetts is.
And an important thing to note there also is that both parties don't have to agree to the divorce to be divorced. So just one person wants to get divorced, even if the other person doesn't want it, you're still getting divorced.
So what we're talking about with this divorce litigation action is a contested petition for divorce. We just want to make it very clear that a joint petition for divorce is always possible, where you both file jointly, you present to the court a separation agreement that you came to either with your attorneys or with mediators, and you present that to the court, and your divorce is over and done with. So,
right, and any time during this litigation process, from the moment someone files for divorce, and at any point after that, you can reach an agreement and present an agreement to the court. And that's what happens in 98% of divorce cases, is you reach a comprehensive global agreement on all of the issues, and that's submitted to the court for its approval. So just because it's called a contested divorce doesn't mean you're taking it all the way to trial. It just means that that's the way it's been filed, and the objective is always to try to reach an agreement, just because of the financial and emotional toll that a trial is going to cost everybody involved.
And we always tell our clients only about 3 to 5% of cases ever make it to trial. And those are really kind of contested, lots of ancillary issues. Most cases settle. So you're not looking at this full track.
Right, and so what we advise, we typically, when we meet people, they're coming in as a potential client, or they've been served, by their spouse perhaps. But if you're contemplating initiating a divorce, or even having or be able to sit-down conversation with your spouse about being divorced, we do suggest that you meet with a qualified domestic relations attorney prior to that, just so we can talk to you about being prepared for that, and anything you need to know before you initiate the process.
All right, so everyone thinks a complaint for divorce is some complicated legal document. It's not. You have a copy of this form in there. This is the complaint for divorce. It's this one-page fill-in-the-blank form. You lay out who you're married to, when you were married, if you have any children, when your marriage became irretrievably broken, and what you're asking the court to do in a very general sense, like a division of the assets, give me custody of the children, alimony. So you fill this out. There's a couple other court-issued forms that you have to fill out and file with it. You pay a filing fee of $220, and you file a certified copy of your marriage certificate, which, if anyone doesn't still have a certified copy of your marriage certificate, you would get one at the city hall that issued your marriage license. They're usually around $20, and it just has a raised seal.
So that's all you need to get the process started, is just to have your certified copy of your marriage certificate or a motion to file it late, and then a complaint for divorce. And typically when we work with people, we draft the complaint for divorce, for them, they review it, and we file for them at the, it depends on what county you live in, but at the probate and family court in your county. And then after that, so when that complaint is filed with the appropriate probate and family court, it's put in their system, it's docketed, and a summons is issued by the court. And we receive an original summons from the court, and that summons has to be served on your spouse, and that kind of gets the clock ticking on the action, the date of service. So it gives your spouse notice that you filed a complaint for divorce and you're pursuing a divorce. Typically we work with clients, if they've decided to file a complaint for divorce and we've received a summons, we work with our clients to arrange, the most, unintrusive time to have someone served. A party can come in and accept service and sign in order to avoid being served by a constable. So we work with clients to try to make that service as amicable as possible.
And all service means is that you're receiving notice, not that you accept the terms of the complaint or anything like that. It's just a due process requirement in the Constitution. Yes, I am aware that somebody filed this action. That's all it means.
So yeah, maybe the most important, or one of the most important things about service is that when someone is served, an automatic restraining order goes into place, which is really important to know. So what that means is that at the time of service, from that point on, there can be no big financial maneuvers. So they're trying to avoid people, moving assets, changing beneficiaries on policies in anticipation of a divorce action. So I think we have the language there, but basically neither party shall transfer or dispose of any property, except for, of course, you can pay your ongoing living expenses, you can pay your counsel fees, those things. I really don't want people closing accounts, moving accounts offshore, like I said, changing beneficiaries on life insurance policies or retirement accounts. So that goes into place for both the parties, and that's a really important protection, and oftentimes that's one incentive to get people to file, because they're concerned if the marriage is going downhill and the parties are talking about divorce, there can be some concerns about financial maneuvering, and that can help protect you. If you file and serve, then that goes into place.
So answering the complaint, when your spouse is served, they have 20 days to answer the complaint for divorce under the statute. It's a little more loose than that. And in answering the complaint for divorce, you saw that the paragraphs on this complaint for divorce, they're all numbered. Basic information. These are our names, this is where we live, and they're going to admit, deny, or say that there's not enough information for them to admit or deny each of those statements. And if they don't have an attorney, there's a fill-in-the-blank form at the court that they can get. In addition to that, they can file a counterclaim. So the way that you ask for relief down here, what you're seeking, custody, alimony, whatever that may be, they can do the same back to you, and we call that a counterclaim. So that creates an action and preserves their rights. Should you dismiss your complaint for divorce, they can still proceed on their counterclaim. One thing that we always point out to people is that you're not at a disadvantage if you don't file first. The term plaintiff and defendant are very loose in family court. So if your spouse were to file for divorce first, you're not at a disadvantage in any way. It literally just means that they filed the action first.
Yeah, the only advantage sometimes to being the one to file is, first of all, you know what to expect, and second of all, you can contemplate with your attorney the timing of things. So sometimes there can be issues that would change the timing, and we can talk to people, we talk to clients about that in more detail. But that's really the only advantage, that you have no notice, you're in control of what's happening, you have control of how to serve your spouse, and you kind of get the ball rolling timing-wise. Sure. So after a complaint for divorce has been filed, and an answer has been filed also, you have a long period, unfortunately, typically, whether it be weeks or months, sometimes years, where the divorce proceeding is going to be pending in the court. So you have kind of all of this dead time where you're trying to either work toward an agreement, you're doing discovery, you're in negotiations. And during that time, most of the time, we need some ground rules in place during the pendency of litigation. you know, who's going to live in the house, who's going to pay for the mortgage, am I going to get support while we're working everything out, you know, what's the parenting plan going to be with the kids, who's going to have custody of the kids. So all those ground rules that need to be in place during the pendency of litigation, those are called temporary orders. So they're not the final order. You're still working toward that final result. They're just temporary orders in place during the pendency of litigation. So oftentimes, most of the time, parties need to either enter into a stipulation as to what the ground rules will be during the pendency of litigation. You know, I'll pay you this much support, you'll stay in the house, I'll move here, I'll have the kids these days, you'll have the kids those days. And if you can't reach an agreement, we go to court and we ask the court to issue a temporary order as to what those ground rules will be during litigation. And we do that by filing a motion for temporary orders. So we just draft up a motion, which is really a request of the court for the court to do something. We substantiate your motion typically with an affidavit, which is a sworn statement by you, and we file that with the court. Then we try to work with your spouse or your spouse's attorney to reach an agreement on those temporary orders. If we can't, then we go in on a hearing on the motion for temporary orders, which is fairly common. And we go into the probate and family court, and you would be before a judge. And one important thing to note is that the judge you're assigned to at the commencement of your action is the judge that you will have during the whole pendency of litigation, unless there's like a retirement or someone moves. So you see the same judge every time you go to court. So you ask the judge to issue a temporary order, and that's very common. It's a pretty informal hearing. There's no evidence taken. There's no testimony. It's just your attorney advocating for you, and then another attorney advocating for your spouse, both presenting your positions and asking the court to issue a temporary order.
And the one thing that we always tell people, and we're a big believer of this at this firm, is that entering an agreement is always better, because when you enter into an agreement voluntarily, you have control over it. You can decide what terms you agree to, where you're going to kind of give and take a little. When you go in front of a judge, you're letting a stranger who's going to hear your case for maybe 5 or 10 minutes decide your fate and enter an agreement that they think is an appropriate action. And to us, that's always the worst case scenario, letting a stranger decide. You don't know how he's feeling that day or she's feeling, how they might feel about your case. They might have preconceived notions. I mean, everyone comes to it with baggage. So if you can enter into an agreement on your own, I mean, it's better for you, it's better for your family, it's better for your children.
It's better for your wallet.
Yeah, much better for your wallet.
But it's important, but oftentimes people will say, well, we've agreed to this, and I know this is going to be fine, so we don't need to pursue a motion for temporary orders. He's told me he's going to pay me this much a week. He told me he's going to move out on March 1st, so I feel fine with that. The issue we have with that is all of those kind of informal, loose arrangements that you may have are unenforceable in the court. So even if you have the most amicable situation and you both agree on what the ground rules should be during the pendency of litigation, we really prefer for that agreement to be incorporated. So you just give it to the judge and say, look, we've reached an agreement. And they incorporate that into a court order, so you have some protection. So if the next month or the month after that child support check doesn't come, or there's some other conflicts or disagreements, you have an order that's enforceable. So you can go to the court and say, look, I have this order, he's not following these rules, help me out here. If you don't have that, you're starting from way back at ground zero as far as trying to get into court. You need to have access to the court to be able to hold an agreement enforceable.
So the other hearing that happens at the beginning is a case management conference. And if no one files a motion for temporary orders, this hearing will automatically be scheduled by the court, usually about 3 months out or so, depending on the court's busyness and the schedule from when you filed a complaint for divorce. And a case management conference is a hearing, and the only point of this hearing is to set discovery deadlines and to set a pretrial conference date. So usually when there's 2 attorneys or an amicable situation, the parties will stipulate not to even have this hearing. They will just come to those on their own, file an agreement with the court administratively, and they can skip this hearing. And if you have a motion for temporary orders first, that'll make sure that you don't need to have this hearing, because you'll handle those things at the temporary order hearing. Anything else?
Right, that's a kind of a non-hearing hearing.
But but if you filed a complaint, this would be the first thing you would get in the mail if you haven't filed anything else. So, discovery.
So, assuming that there's been a complaint filed and it's been served, within 45 days of that, which is a very loose, it's a rule, but it's really not a rule, it's kind of a loose guideline. Within 45 days of service, the parties are required, under the rules of domestic relations procedure, to exchange some kind of preliminary financial documentation. And the court has tried to streamline the process and make it less expensive for everybody by just having this mandated preliminary discovery, and also to provide some transparency between the parties, because they are aware that you can't make any educated decisions, even in the most amicable situation, or reach any sort of agreement if you don't have full information. You need to be an educated decision maker. So the court requires that within 45 days you exchange financial documents that relate to the last 3 years. So they're your last four pay stubs, and then the last 3 years of bank statements, retirement account statements, last 3 year of taxes, which if you file jointly, you probably have access to anyway. So the parties just are mandated to just go ahead and do this exchange without anyone having to file a discovery. And typically we wouldn't reach an agreement before, regardless of how amicable it is, before that preliminary exchange of information, just because we need to do some level of due diligence to make sure you're aware of your financial circumstances and your spouse's financial circumstances, and there've been some minimal level of financial sharing. Also, in that 45 days, you need to exchange what is called a financial statement. And we can talk about a financial statement in more detail, but that may be the single most important document that's to be filed, other than your agreement that you're going to hopefully ultimately reach. A financial statement is a court-issued form that all parties, even if you and your spouse settle in a week, you reach an agreement, everything's going great, you're going to go into court and you're going to ask the court to approve your agreement like every single person getting divorced has to do. You have to file a financial statement because the court needs to be aware that you've exchanged financial information. And a financial statement is a statement that you sign under the pains and penalties of perjury, and you disclose your income, your expenses, your assets, and your liabilities. And you exchange them with one another. So you have a full picture of your husband's a snapshot of his current financial circumstances, and he has a picture of your current financial circumstances. And we work with our clients to prepare those financial statements and to prepare them as accurately and completely as possible, because like I said, it's signed under the pains and penalties of perjury, and it's a really important document, not only for your divorce, but if anything comes up down the road, after you get divorced, years down the road, there are things called modifications where you're going to come back maybe and ask the court to change some of the terms of your divorce. Your financial statement that you filed at the time of your divorce is like this baseline document that they constantly refer to. So we work really hard with our clients to make the financial statement as accurate and precise as possible. So those are exchanged, those two kind of buckets of documentation are exchanged within the first couple months. And we work with our clients to do that. Now, if that's not sufficient and you feel as though you need more information, you have also some elective discovery that you can serve on your spouse if you want to ask for more documentation, if you want to ask questions. They're called interrogatories, and we draft those on behalf of our client, and you serve those to the other party, and they have to respond by either answering and producing relevant documentation. And you can conduct discovery pretty much during the course of litigation. Whenever you see fit, you can supplement. And the other mechanism for discovery is taking a deposition. If you feel as though you need to go beyond paper discovery and you need to have your attorney sit down with your husband and ask him a series of questions for either information gathering or to assess how he's going to do as a witness, we can take depositions, and we can talk to you about that in more detail. So those are kind of the most common mechanisms for gathering information. It's called the discovery stage of a case.
The only thing I would add is that during litigation, too, we can send out subpoenas. They're called keeper of the record subpoenas. So if you believe that the other side is giving you incomplete records, you can subpoena their work records. We can subpoena any bank that there's accounts at, things like that.
Employer.
Just try to find information that we think is being, withheld for whatever reason or is incomplete for whatever reason.
Right. Like recently I had a case where the husband gave us a financial statement that didn't include any, only included business accounts, and we were fairly suspicious that there were some personal accounts. So we sent a subpoena to the bank asking for all of his accounts, and in fact, like 4 personal accounts came back. So had we not done that, we wouldn't have a complete picture of what the husband's assets were, because you can't decide on what a fair share of your assets are if you don't know what the total assets are to begin with.
Right.
Is there a way to check assets by like social?
No.
Or
Nope.
whatever?
No, tax returns help. If you have someone who knows how to read a tax return, that helps. But we've gotten pretty good at doing the best we can, but there's no check anywhere. No, we look at registry of deeds. We can look.
It's It's more like, I know he has options and like stock options, and honestly, he doesn't, I don't even think wanna hide stuff, he's
So that stuff
really
is,
clueless.
So
I
that
don't
would,
even
that
think he
we would
knows
get
who
through
they are.
subpoenaing employer.
yeah.
Okay.
Or request for documentation, you know, asking about, that's really pretty standard, actually,
Okay.
stuff.
The harder stuff is like some offshore account that you don't know exists, and you
there
wouldn't
are-
know to subpoena that big.
There are forensic accountants.
Yeah,
I mean,
yeah.
If you really
Okay.
think, and, you know, there's some very good ones that I've worked with, who can follow a trail of
Yep.
money. But you have to be willing to think that there's enough out there that you're willing
Yeah,
to pay a
it's worth it.
forensic
Right,
accountant.
right, and that's
Right.
kind of a cost-benefit
Yeah.
analysis. But as far as options, that's actually,
Stock options are
That's easy.
employment benefit,
Yeah.
those are very easy.
yeah.
Subpoenas are a very inexpensive option. You know, they take about 20 minutes to draft and $50 to serve. You know,
And then you pay, like, you know,
You know.
sometimes a processing fee, but.
yeah, for the pages, depending on what the bank charges. But,
Yeah.
I mean, that's an inexpensive.
But that's
discovery
another
tool.
reason to file, because you can't subpoena documents unless you have,
Open litigation.
right, you have to have a case filed, you know, with the probate and family court. You can't just ask for documents on your own.
So, assuming you still haven't settled, the next court date that's going to be scheduled is a pretrial conference, which we'll talk about on the next slide. But prior to the pretrial conference, the court says you must sit down in person, absent there being a restraining order in place, with your spouse and with the attorneys present, and you need to at least talk about settlement. You need to go through the checklist of issues that exist and see what you can agree on and what you don't agree on. And it's a really, really important opportunity, because sometimes when you put 4 people, parties and their attorneys, around the table, a lot can be accomplished. It just requires you to sit there. And a lot of times it's things that wouldn't be accomplished, you know, even on a conference call where you don't have to sit face to face with that person.
Yeah,
So-
and sometimes they last 5 minutes, and sometimes they last 5 hours, and you walk out with an agreement. It really just depends on what you're willing to put in, you know. But that's something you can't opt out of, so you've got to meet in person and give it a try at least.
So then we have our pretrial conference. And the pretrial conference is a hearing where the parties articulate to the judge what the remaining contested issues are on their case. And the attorneys or the parties that they represent themselves have to file comprehensive pretrial memos in advance of this hearing that really lay out the background, the procedural history of the case, what issues are contested, what issues aren't contested, what facts the parties agree on. If this case were to go to trial, what witnesses you would call, what exhibits you would present. You have to talk about the pretrial 4-way meeting you had, when it happened, what happened at that meeting, did you make any progress? And you present this to the court at the hearing. The judge will hear one side, then hear the other, and the judge will give you feedback, hopefully, that kind of says, well, without hearing the evidence, this is how I might come down on this issue without saying any more, and really use this as an opportunity to help the parties reach an agreement on the remaining contested issues. Sometimes parties will come in with a partial agreement, and the judge will give them some feedback on the rest, and they'll go in the hall, and they'll kind of settle things out, or they'll schedule a further date to come back with an agreement. Other times, you're just like, nope, we're still too contested at this point, and a trial date is scheduled. The courts, especially probate and family court, are just so backed up that when you're talking a trial date, some of the judges right now in Middlesex County, for instance, if you went in for a pretrial tomorrow, you're not going to get a date until the end of summer for your trial. So there's still a huge chunk of time of waiting that's going to happen. And a lot of times what happens is during that chunk of time, the parties settle before the trial, and the trial never happens.
So the pretrial conference is kind of like the big daddy before the trial. It's kind of like the first, you know, it's a big, you're actually submitting substantive, you know, memoranda, like Melissa said, and you're really talking about the law, what, you know, how you feel the law supports your position, how the facts support your position. But it really is such a great opportunity, especially if you have a good judge, to hear from them and hear their perspective. So not only is it an opportunity to present your case, but to hear from them, because hopefully you can get an idea of what the judge is inclined to do, and then you can make a good whack at settlement based on that. So very often cases settle pretty shortly after the pretrial conference. They've heard from the judge on the remaining issues. They have an idea of which way the judge is leaning, and that kind of helps them cross the finish line as far as an agreement goes. So the better judge you have, the more feedback they're going to give you.
So how does that work? If you get a good judge, the better judge you get, I mean, how does that
It's a lot. There are a lot of judges. There are a lot of judges. Let's
Yeah, we
just
know
say
that.
that.
So how do you
And
not get a
there are
really bad
some
one?
judges, when you're assigned, you say to yourself, I am going to settle this case. I cannot try this case in front of this judge.
It's random. When you go to, every time someone files a divorce, it's a random draw of the judge. They kind of just go through a rotation.
And your attorney, when you're assigned a judge, will say, this is my impression of this. We're familiar with all the judges. We've been in front of them, you know,
Right.
between all of us many, many, many times. So when we find out who's assigned to your judge, we'll let you know our frank impression. And that does come into play when you're deciding whether or not to reach an agreement. stinks, but it's true, you know? So there are certain judges who we know, favor certain positions, where certain judges who we know are totally unpredictable, and you don't want to go before an unpredictable judge, ever.
You know,
And then there are a lot of, judges who are better and are good, and we feel more comfortable, and we can really gauge where we think the case is going to go if, they rely on the law. There's some judges who don't read what you submit to them. So it's unfortunately a little bit of a luck of the draw. In the past few years, not to get too much into like the legal stuff, in the past few years, the state has passed a couple of really big laws in family law practice, having to do with alimony and having to do with child support. So they've tried to streamline the process, I think, a little bit, because in the olden days, literally, you could have two different judges and have two crazy different orders, like all over the place. So they've tried to streamline it so the results, the possibility of the results is narrower. So in theory, the effect of the judge shouldn't be so drastic, but there still are, real effects of a judge.
yep. And we can know, like, there's 8 judges in Middlesex County. We know on certain issues how certain judges are going to rule, because they rule the same way on different cases, but it's going to be different than the judge who's 2 courtrooms down the hall. And we know that. That's just the part of having attorneys who practice in the same courts all the time. We can tell you. If you're down to, like, who's going to pay college tuition, and what allocation that's going to be, we can tell you how your judge is likely going to rule at trial without you even going there. And you can decide if you want to try to chance it for that 5% chance of winning what you want or settling, because this is how the judge consistently rules 99% of the time.
Yeah, and some judges are really much more helpful in helping you achieve settlement than others. So
Right.
that's another thing to consider. Sometimes, with I have a case now, I'm like, we just need to go to the court and we need to hear the judge's input, and then I think we'll settle. So who you have for a judge is pretty important. So one important thing, and I feel like often this is like kind of a misunderstanding that people have, is we're talking about litigation. I like to think about litigation and settlement as like parallel tracks. So all the time that these stages of litigation are kind of chugging along, on a parallel track, we are continuing to try to hammer out an agreement. We need to have them as parallel tracks, because if the settlement talks fall off the tracks, we need to have access to the court to protect you. So it's not, if we're pursuing litigation, it doesn't mean we've said screw settlement, we're just all, full steam ahead on going to trial. That's not the case. We're trying to pursue both, but we need to have the case docketed, and we need to have access to the court should your settlement talks go south, and we need to go to the court and ask them to do something for us.